Welcome to Behind the Headlines. I'm Lee Pacquiao. Moments ago, the United States Supreme Court released its decision in the Myriad genetics case, which centers on the question of whether patents may be granted on parts of the human body. Joining me now to discuss is Tom Goldstein. He's the founder of SCOTUS blog, of which, of course, Bloomberg Law is a sponsor. Tom, welcome back.
Thanks so much. It's great to be with you again, Lee.
Of course. So we have a bit of a mixed bag here. It was a unanimous decision, but a bit of a split, or at least the media is portraying it that way. What do you make of it?
Well, on the big question of whether you can patent human DNA, the justices said unanimously you can't. That occurs in nature. You haven't invented anything. But I think the justices were very conscious that they didn't want to discourage investment in this field and innovation. They wanted to make some patent protection available, and so they said, we're going to say that patent eligibility extends to synthetic DNA, which they call the cDNA, and tests that you might invent on the basis of DNA. And still, then, they were clear that they're not promising that any given test or any synthetic gene might be patentable, but they say that's at least something that falls within the patent laws.
Time, of course, will ultimately tell how good a job the court did in striking the balance or their intended balance. But as this decision looks today, all fresh and new, how good a job do you think they did?
I think this is really the middle ground that most observers thought was most sensible, because the idea that you could patent a human gene, while it might really encourage research into genes, does put a block on a lot of innovation, a lot of efforts to create new genes on the basis of the original gene, a lot of efforts to create new and useful tests. On the other hand, the justices rejected the view that kind of nothing in this field should be patentable. Even if you do make a new synthetic gene, that it shouldn't be patentable. And the justices, I think, were convinced that, well, look, that's not in nature. You've really done something there. And if it's non-obvious and meets the other criteria for getting a patent, it should be patent eligible. So they went, I think, right down the middle of the road, and it was impressive that they were able to do it in a short opinion of 18 pages that was unanimous with only one separate concurrence.
Right, we're going to get to the concurrence in a bit, but it's not often that this Supreme Court, or any Supreme Court for that matter, unanimously decides something. Were you surprised at the United Front?
Well, in any given case, there's a good chance the justices are going to be unanimous. They decide almost half their cases 9-0, but you're quite right that when we get to the end of the term, in the cases that are thought of as the hardest, unanimity tends to break down. And so it was surprising to me that the justices decided 4 cases today, and they decided them all 9-0.
And, of course, Clarence Thomas ended up penning the decision here. Were you surprised it didn't go to another justice, say Justice Breyer, because he decided the Mayo case?
In the end, I'm not. I think it really depends on what is in front of the justices in any given month. I think both Justice Thomas and Justice Breyer, and to some extent Justice Kennedy, have a familiarity with the patent laws now. I think the justices in the end also thought this was a relatively simple case, not one that was going to require incredible detail and big fight.
Right. So it was a unanimous decision, as we said, but there was that one concurrence sticking out. Justice Scalia agreed with the court in terms of how they voted, but he added his own verbiage in which he seems to say that he doesn't believe in molecular biology.
Yes.
What to make of that statement? Is that humility, or is that something else?
Well, that's the big debate. There are really 2 ways of reading that solo, short, concurring opinion by him. One is, gosh, this stuff is over my head, and I can't join an opinion that, promises to be a complete recitation of how science works, because I'm not a scientist. Another one, where he has that phrase that says, I can't commit to know it or even to believe it, does suggest some doubt about some of the basics about modern scientific understanding of biology and how DNA works. But it's so short and so cryptic, it's hard to know exactly what to make of it.
It's an interesting addendum to what's occurred here. Tom, what's next for this space? It's a big decision that's going to have profound effects for certainly biotechnology as it works in the United States as an industry. Do you expect more litigation down the road, or is this going to quiet things for a while?
No, I think there's a new frontier in litigation. A lot of the fundamental patents on human genes, which the Patent and Trademark Office issued, are now actually expiring. And so there's not a huge pent-up set of investment that's dependent on the validity of these patents. But the next generation, the cDNA, the synthetic DNA, the tests, the innovation on the basis of the genes, Well, now the Supreme Court has done something very helpful to those who want to be able to claim patent protection for their investments in innovations. They've said it is patent eligible. But there are going to be real questions about, for example, whether those inventions are obvious and therefore not patentable. There's some bad language for those seeking patents in the case that says, for example, that using very well-established methods, Myriad here created the synthetic gene. So that's where the fight moves on. And there always will be fights over this sort of thing because there's so much money at stake for new tests, for new genes, for all kinds of innovations.
So it sounds like Justice Scalia might do well to take a little bit of molecular biology into his reading these days.
It may be coming back to him. That's right.
All right. Thanks, Tom. This is really interesting.
Oh, thanks for having me.
That's Tom Goldstein, founder of SCOTUS blog. If you'd like to learn more about the cases and issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. Thanks for listening.